All rise. The Court of Appeal in and for the 6th District of the State of Florida is now in session. The Honorable John K. Starter, Judge, presiding. All persons have been business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please remain standing for the pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You may be seated. All right, welcome to session of the 6th District Court of Appeals. I am Judge John Stargell. I will be presiding today. Today, we have a special privilege of having a couple associate judges that are going to join us on our two cases. We have with us the Honorable Christine Marlewski, who's serving today as an associate judge of the 6th, but her day job is a judge on the 13th Circuit in Tampa.
Good morning.
Then I have my colleague, Judge Jared Smith, also joining us on this panel. After this first case, we will take a break, and then we'll come back, and then we'll be a different associate judge joining us for the second case. I want to remind everybody here to put your phones on silent or stun mode so we don't have any unwanted distractions. And we have the first case before us. I'm going to ask the attorneys to identify themselves for the record. Jason Garman versus Megan Garman on behalf of Jason Garman. Okay, and please identify yourself.
Good morning, Your Honor. May it please the court, my name is Allison Perry, and I represent the appellant, the former husband, Jason Garman, in this appeal.
Okay.
I'd like to preserve.
Okay. Oh, just go.
Good morning. My name is Wade Luther, and I represent Megan Garman, who is seated to my right.
Thank you. All right. Now you say you would like to reserve 5 minutes for rebuttal?
Yes, please, Your Honor.
All right. Just 1 second. I'll keep the record. Of course, my computer's moving down. That's okay. All right. You're ready to begin? You're recognized.
Yes. This is an appeal of a family law post-judgment attorney fee award of $75,000 that my client was ordered to pay. The husband challenges the award based on the fact that there was no competent substantial evidence to support the award. Therefore, it was an abuse of the trial court's discretion, which is the standard review for this case, is abuse of discretion. Here, there is no competent substantial evidence to support the $75,000 attorney fee award, so this court must reverse. If you look at the hearings that are relevant to this matter, at no time was the wife's financial affidavit entered into the record. She did not testify regarding her need, and no other fact witnesses testified regarding the wife's need. The record is completely devoid of any testimony or evidence to support an award because need was never established.
Now, despite the fact that the financial affidavit wasn't formally admitted, couldn't the court have considered the financial affidavit or taken it under judicial notice?
No, because filing a financial affidavit in a file is not the same, and taking judicial notice of it is not the same as putting something into evidence. You still have hearsay to deal with. And since the financial affidavit is, for the truth of the matter, assertive, it needed to be testified to.
What about the fact that the husband's counsel never objected when the judge was saying that she was going to, or the judge was going to consider the financial affidavit and the W-2s?
Well, the W-2s could be considered because they were entered into evidence. But I don't recall that the judge saying that, except in the actual order. The judge reflected that the judge considered the financial affidavit of the wife. It's not the same. It has to be entered into evidence. This case is very similar to the recent case of Grady out of the Fourth. I sent it in as supplemental authority. And in that case, like this case, the husband argues the wife failed to provide evidence establishing her need for attorney fees award. Wife did not testify to her financial need for attorney fees, but only testified that she had retained counsel. You know, likewise, there was no testimony regarding the wife's need in our case, and the only thing that happened was the attorney testified, Mr. Luther testified regarding the fees that he had incurred.
Assuming we agree with you, what do you think the proper remedy should be on remand?
I think you should just strike it. Just strike it as, say there was no competent substantial evidence to support the award because the wife never established her need. Therefore, the order is stricken as reversed and stricken. So, but the greatest case is great. It's right on point. It's very recent. And then there's another case that's very recent, the Haster case out of the First District Court of Appeal. In Haster, do you want the cites for Haster? It's in my brief.
No, that's fine, we have it over.
Okay. So the first DCA has gone as far as to hold that 61.16 fees, attorney fees, are only prospective in nature to make sure that individuals have competent counsel. And it shouldn't be used to reimburse a party. So the Haskell case is something that this court needs to consider because here the wife was seeking reimbursement of her fees. All the fees have already been earned and paid for.
So you would not believe that the parties and the judge in the lower court would look merely to what the husband's assets were. It was like $1 million versus $500,000, his income versus her income. That's just not enough without on the record having to actually say, we're gonna show need.
That they have to show need, and the only way he got what her net income, her net assets were from the financial affidavit that was not entered into evidence. So the court considered documents that were not admitted into evidence when making its attorney fee determination.
And going back to strike the award, you don't think we should give them the opportunity to remedy that?
No, they've already had the opportunity to present their evidence and they failed. So absolutely not. They've had their day in court. They don't get a second bite of the apple. I think the law on this is pretty clear cut. It's all spelled out in the briefs. And in the greatest case, which I put in as supplemental authority, that case is really right on point. And it explains what has to be done. This court, the 6th District, has issued 3 opinions on 61.16 fees, and none of them deal with this issue. So I did look to see if there were any cases on point from this district, and there aren't any so far, but hopefully there will be soon. So I ask that you reverse, strike it, and there not be any remaining proceedings.
What's your,
Go ahead.
what's your position on whether the statements made that that the council wasn't there to contend the entitlement is in the stipulation to entitlement to fees?
I don't understand, I'm sorry.
So the Appellate's brief focuses on a stipulation or the statements that were made at the lower court at the hearing saying that we understand the court has ruled on entitlement and the brief found the amount to be reasonable or the hourly rate. We're not here to contend that. We're just here to argue against the number of hours. How is that not a stipulation by the husband's counsel that entitlement, that the wife is entitled to fees?
Because entitlement had been decided in September. So you can't appeal entitlement because it would be premature. You have to get an actual fee amount before you can appeal attorney fees order. So the fact that they went to the hearing, he was not required to, I object to entitlement, because it was already established in the earlier hearing. And then there was a motion for rehearing that was done where we absolutely objected to entitlement to the fees. So you do not have to object at the beginning of a hearing determining the amount of fees that entitlement should not have been ordered. That it wasn't the time.
So, counsel, I follow your argument in relation to the lack of substantial competent evidence for the need. The part of the remedy I'm on the fence on. I see a case. This is a little novel. It is and it isn't. Out of the 5th District, Saporito, 831 Southern 2nd, 697. And in it, there was a consideration by the court of a situation very similar to this, and the court remanded for the trial court to make the express findings if they're able to support the fee award. There was an affidavit, as in this situation, and in footnote 3 of the case, they said that had there been no mention of an affidavit, that it would have just been a strict reversal. But in this particular case, it says this case is distinguishable from the normal line of cases where you would just do a strict reversal because an affidavit was presented to the trial court to substantiate the award. The fact the affidavit was not moved into evidence is not fatal, given that Samuel did not object below to the court's consideration of the affidavit without the affidavit having been moved into evidence. What would your response be to this case?
I did not know about that case, else I would have had it in my brief and I would have thought about it more. I think that's a footnote. I think it's dicta. I don't think.
It's definitely not dicta. I mean, it's absolutely, it's critical to the decision path of the court. In full disclosure, they cite in support of this proposition, which I'm not familiar with, frankly. They cite Falls versus Sheriff of Leon County, a Florida Supreme Court case from 1981, which in my opinion doesn't stand for anything of what they just said.
Okay.
So it's a totally different, unrelated case. Not a family law case, not an affidavit. Very, very different factual circumstance. I was trying to figure out, if I sided with you on this, what do we do? This case popped up, and I was curious as to your position on it. So that's why, counsel, I'm not here
Okay.
to, play the gotcha game, but if you had a response to it, I was going to give you an opportunity to speak.
I think that case goes against the other cases that hold that you have to actually introduce something into evidence for the court to consider. And their cases are cited in my brief. And then if I would have known about that case, I would have found some more cases, and I'd be glad to provide supplemental authority that says you don't get a second bite of the apple. You don't get to go present your evidence and get to have testimony and get the affidavit in after you've had a chance to have an attorney fees hearing.
Coming off of what Judge Smith has indicated, hypothetically, even if the financial affidavit had been admitted into evidence, what's your position on whether the lower court would have had enough, or whether with that change only that's in evidence, would then there have been enough for the attorney's fee award?
No, because they still have the burden of proving the need, and she needed to testify regarding that she actually had a need for payment of these fees. And that was never done. So it should still be reversed. Are there any other questions? Okay. See you in a few minutes.
Good morning, Your Honor. The issue in this case is clearly whether there was a stipulation or whether there was not. This is not contrasting case law. The case law that the appellant cites.
So if we don't believe there's a stipulation, then you agree we strike the award?
Please don't make me agree to that on the record here, but I don't have a great argument unless there's a stipulation. So I'd have to say yes. But if you look at the history of this case, the issue is when can the court rely and the other litigants rely on attorneys' statements, multiple statements? So we had the trial September 26, 2023. The record shows that on page 1116 of the record, the court's looking for stipulations. And so one of the questions that the court asked to appellant's counsel is, all right, so there's no dispute about mom's pay. The former husband's attorney says, correct. Then we have a little dialogue about how much it is, and we're within a few $100s. I specifically said to the court that, that I'm citing the financial affidavit that's in the court file. So we have the trial, opposing counsel, appellant's counsel doesn't object to anything. The court in the ruling that day said, on page 1323, his assets well in excess of what the court record reveals her assets to be. There's a clear indication that the trial judge was looking at the financial affidavit that opposing counsel and I had just discussed and cited. I was citing income from that.
I want to ask you the same question I asked her earlier. Does the difference in income equate to need? Does the difference in assets equate to need automatically? An argument for need?
No, so it takes more than just, I agree that it has to be more than just a disparity in income. It has to be a totality of circumstances. I won't jump ahead too far, but when you look at the actual order awarding fees, the judge was very specific, and I think there's 16 different findings that I think support the need. So the judge did not rely just on disparity of income or disparity of assets. But back to, so we discussed at the trial, the court clearly says, I've looked at the financial affidavit, and then on that same, within a few lines, same page of the record, the court asks if there's anything else that she needs to rule on, and the former husband's counsel says, I don't believe so.
So then, same question I can pose, what's your position on whether that equates to the lack of objection to the financial affidavit means the court properly considered it in light of?
I believe, and I'm sorry,
Go ahead.
yes, I believe so, and Judge Smith, I was, this Superior case, that sounds exactly what we're dealing with. This is not a case where nobody mentioned a financial affidavit, there was no discussion of it, and the judge just went through the file to find the financial affidavit and make decisions on it. That's not this case.
So as a trial judge, could I not consider, okay, the financial affidavit, that gives me these different levels of disparity of income?
Yes.
Does that equate to need?
Not necessarily, but I do have to raise an issue that wasn't really appealed. The only time the argument changed for the appellant in the reply brief after I've done my answer brief. Their initial brief was there's no evidence. Then I do my answer brief, and then in the reply brief they say, but even if the evidence is there, she shouldn't get the award. So I don't think that's fair to have that in this appeal. However, I agree that there's cases on both sides that say that disparity of income or disparity of assets alone is not enough. However, I'm familiar, and I can't cite the cases that I've dealt with, where when there's a significant disparity, there was a case that I relied on in a different appeal where there was a multitude of disparity in income.
Disparity between assets or income?
Incomes. I'm just talking about incomes for right now. The Court of Appeals said no, when there's that big of a gap, then it is appropriate. So I don't think there's a clear-cut black and white law of, what range of disparity. I think that if there is a significant disparity in income and a significant disparity in assets, I think that the court can base an award on that. However, that's not the
Let me ask
case.
you this question. Switching from income to assets. One party has 5 million worth of assets, and one has 2.5 million worth of assets. Does that equate to a need?
That's going to be just
How much million versus a $500,000? Does that equate to need?
I think it can, depending, again, what is the $500,000 in assets?
But isn't that what needs to be presented?
But it wasn't. My theory of the case is it was presented to the financial affidavit that shows, it's on the record, that shows that Ms. Garland's assets, even though she's got $500,000 of assets, most of it was in a house. Some of it was in a retirement account. And so I think the court can properly look at liquid versus non-liquid. And the trial judge did cite to that the former husband had nearly $1 million of liquid assets. So I think that, again, that on abuse of discretion, when we look at the actual order that granted the fees, the trial judge was very specific on findings of income, findings of merits of the litigation, all the Rosen factors. So I think that the judge supported it, but I do want to make sure I have time to get to the stipulation. So we have this trial, and again, it was referenced that the judge looked at it. There's a motion for rehearing days afterwards, and in the motion for rehearing by the appellant, they argue in their written motion that the court failed to determine new child support based on the former wife's increased income. They're citing the financial affidavit because the contrary, I think it was a mistake, but the W-2s were not introduced into evidence. So the appellant himself, through counsel, is citing to the financial affidavit that now they're trying to say should not have been considered.
What is your position on, if we accept that there was some sort of stipulation, what, was trial court still required to make factual findings as to need and ability to pay, and did it?
Yes, it was, and yes, it did. So if you look at, I think it's paragraph R of the order on fees, again, this was entered on June 28, 2024. There's, I think, count them all, but there's got to be 20 different factors the court looked at. And starting in paragraph paragraph R, it talks about the assets of each party. It talks about the income of each party. It talks about the litigiousness of the case. It talks about the fees and the reasonableness of the fees. She did cut out some of the fees. So the key, I think, for the proper findings is the order entered on June 28, 2024, because I think the trial court did a sufficient, thorough job of reciting. But again, it all comes down to, did the trial court rely on the financial affidavit? So in the motion for rehearing, the appellant is relying on the financial affidavit that they're now saying should not be considered. And then at the hearing, on page 1028 of the record, former husband's attorney argues to the court did not take into account the former wife's increased income. She's citing exactly to the financial affidavit because there was no other evidence of the increased income except for her financial affidavit versus the underlying final judgment. Is most of the difference.
Isn't the financial affidavit kind of a snapshot in time, and how do we know whether the wife had already paid the fees, whether from the record that those weren't something that was a different account that perhaps isn't there anymore? How can we read into this?
Well, you can read into it by the fact that when the financial affidavit was filed, I don't have the date with me, but it was not a 2-year-old, 3-year-old financial affidavit coming to the trial. Most in Orange County, most of the pretrial orders require an updated financial affidavit, although I can't tell you when it was. But I'm very confident it was not some old, stale financial affidavit. So I think that the evidence of the financial affidavit, the numbers, the assets, the income, could be considered contemporaneous with the judge's decision. Again, it wasn't like, well, what were the financial circumstances 3 years
Well, I think that's kind of the point, is if it was contemporaneous with the judge's income, those fees, nothing in the record suggests that those fees were outstanding, they had been paid.
But it doesn't have to be, I'm unaware of any case law that says that the fees, for example, if the fees are paid on a credit card, if the fees are paid by borrowing, if the fees are paid by taking a second mortgage. So the fact that the fees are paid or not paid, I don't think is determinative of the award, in my opinion. But so now, former husbands relied on it twice. As this court knows, they appealed that supplemental final judgment. And when they appealed it, appellant's counsel in that case cites the exact language in the trial transcript that I'm talking about. And the exact words were, from appellant's counsel, the parties stipulated that the former wife's monthly income was currently $13,305. Now we got former husband not saying anything when the court says I looked at it. We got the former husband relying on the financial affidavit when it suits them. We've got an appeal where the former husband refers to it as a stipulation.
The stipulation as to income, you've already admitted, is not the same as the stipulation to need.
It's not, but the stipulation, where that stipulation came from was the stipulation that the judge could consider the financial affidavit. I agree, and I see the distinction there, that we're only talking about income here, but the only place you can get income was her financial affidavit. And so we've got the court saying, I looked at the financial affidavit, already addressing assets and liabilities, and now saying the appellant's counsel calls that a stipulation. So I think it's pretty clear that the judge is looking at the entire financial affidavit, and the former husband understood that. So now we've got the appeals affirmed without opinion. Now we've got the hearing on the actual fees nearly 8 months later because there was a delay. In the record at page 1580, I am arguing to the court, and I make it clear that I'm relying on that the entitlement has already been found. And then,
So, counsel, I've read through your argument about the stipulation, and I'm seeing acknowledgement that, there's acknowledgement that the court made a finding, that there's acknowledgement that the court made a finding. But how's an acknowledgement the same thing as the stipulation?
well, I think just like when you have a verbal agreement, what do you look at? Okay, you look at the specific terms, then you look at the behavior of the parties, right? So if you've got a verbal agreement, you're trying to figure out after the fact, did one party start executing? Did the other party start executing? Did they both, start enjoying the benefit of whatever agreement they had? So it is a totality, right? So with regard, except for appellant's counsel specifically saying that it's a stipulation, I think you have to look at the totality of what we're doing. So we've got the former husband relying on it, not just accepting, well, the court had an entitlement, but using it to their advantage, calling it a stipulation. And then as Judge Marluski said, you already cited to what I think is very important, that even at the hearing, when something could have been corrected, there could have been more evidence. Appellant's counsel acknowledges our position. We understand that there's already found an entitlement. And the most important quote of that, which I think Judge Marluski said, was, we're not here to contend that. So once again, reaffirming to the trial court that we're accepting the entitlement. The issue is...
But it was already found.
Yes.
It was already found at that point.
I do understand that, but at the same time, there's nothing that would prevent them at that hearing from re-arguing, oh, by the way, Judge, you never found, there was no substantial competent evidence.
But that, unfortunately, what you run against with that argument is the change that they made in favor of rules of procedure that says you can raise substantial competent evidence at any time. And that's, I think there may have been a day and time where you could make an argument like that, but I just don't, I'm struggling to see how that can be made on this record.
I do understand what you're saying, but so if not, then what we're saying is that attorneys, and this is not disparaging Ms. Perry at all, but that attorneys can say things and do things that mislead, whether purposely or not purposely, mislead the other side and the court. Now remember, the judge's order on the fees specifically has a finding, I'm paraphrasing slightly, but the parties agree that the only issue for the court to resolve is the number of hours to be awarded.
That was after the court already made the finding of entitlement. So the court makes the finding of entitlement.
Mm-hmm.
We move forward to the next leg of the jury, and everybody says, now, you already made the finding for entitlement, so we're just talking about hours.
So that's an interpretation issue, which I agree. I interpret it as them acknowledging that it was appropriate. I understand there's an argument that they're acknowledging that's what the court ruled and I don't agree with it, right? But then if we go to abuse of discretion, the judge was looking at me, looking at opposing counsel, looking at everybody in the courtroom, and I think on an abuse of discretion standard, the judge determined that what the attorney was saying, based on the tone or inflection or whatever, that they acknowledged that entitlement was appropriate. Because, again, the judge put in there that the parties agreed to it. So the judge...
it says the parties agreed that the remaining issue was
Correct.
The reasonable number of hours. It doesn't, I don't see anywhere, you use the word, I know you use it more probably as an argument than you do as saying this is in the record. You use the word stipulation, the party stipulated. I don't see where I ever see the husband's counsel saying, I stipulate that there's a need.
Not that they stipulated that there's a need. I agree with that. They stipulated to the court reviewing the financial affidavit and considering the financial affidavit. I agree with you. The husband never stipulated that she has a need. So there's a distinction there. The issue is, it goes all the way back to the trial, and was the court appropriate in reviewing and relying on the wife's financial affidavit, which had income and assets as compared to the husband's. So that's the stipulation, that yes, Judge, you can look at the financial affidavit even though we didn't put it into evidence. I agree with
Isn't
you.
that them saying, we're not gonna go into her W-2s, all of her information, we're accepting the financial affidavit? Then you actually have to go to need, and that's what I'm seeing a fair spot in the record where we really equate income disparity and asset disparity to need.
I understand.
Stipulation there.
I understand, but again, on an abuse of discretion standard, the trial court was there, the trial court heard all of the evidence, the entire trial, the fees, reviewed the entire file, saw the course and scope of the litigation. So I think it's more than just the numbers. And again, if I cite you to the order that imposes the fees and all of the findings that are there. So I think the trial judge actually went to great lengths to ensure that the record showed why she gave fees. I only have 2 minutes left. I do need, sorry. Go ahead.
You didn't have the opportunity to brief Greatness because it was cited as supplemental authority. How do you distinguish that case?
I'm sorry, I have to refresh that. The Hausler case I'm familiar with. What was the other case?
Greatness, which was cited in supplemental authority, which essentially is the case where the court reversed, it was a 5th District Court of Appeal case where cited as supplemental authority was reversed for failure to make findings. And in that case, I believe the financial affidavit was considered.
Okay,
Well, July 14th was filed
Yes.
for supplemental authority.
okay. I distinguish it on, as far as I understand in that case, there was not this big discussion about the financial affidavit. There was not affirmative statements. I relied on the financial affidavit in the court, and there were not the appellant relying on the financial affidavit itself. So I think that's distinguishable. Again, if nobody mentioned the financial affidavit and it wasn't put into evidence, then that would be a different case. I wouldn't have the same argument here.
The court quotes its earlier decision where it says, as we have explained, the party seeking relief must show some need. It is not enough simply to show the adverse party ability to pay the fees is greater than the party seeking relief, or that the award is based on the relative financial strain of paying attorney's fees.
Yeah, yes, I do understand that. And again, I feel like we touched on that a little bit, that when there is, it's more than just a disparity. It's the type of assets, whether they're liquid or non-liquid. It's the course and scope of the litigation and so forth. I've got less than 2 minutes left, but I do want to raise one issue. So the procedure of this was, we had the trial, and at the end of the former husband's evidence, I did a motion for directed verdict that had proved his case for modification. The court then instructed me to go ahead and testify about my attorney's fees. So I did. Then the court said, okay, let's take up your motion for directed verdict, to which we argued. And the trial judge never really ruled, yes, I'm granting directed verdict, but instead just sort of went into closing argument, which was favorable to us. But as a result, the record shows on page 1315, the judge was sort of interacting with both attorneys and made a comment that I didn't agree with. And so I commented back, no, I don't think that's right. And I said, I've got evidence to support that if needed. And my client hadn't even testified yet. And the judge said to me, the evidence is closed, right? So the procedure of this is, we didn't really have a chance to put on our case. So I don't want you to remand, or I don't want you to reverse it. I don't want you to remand that, but we're seeking that it should be affirmed. But if it is reversed, I feel like it has to be remanded because she didn't get her day in court. She didn't have her opportunity based on the procedure. So any other questions?
So counsel, you made a point to say that there was a stipulation that the affidavit be considered. Correct?
Correct, yes.
Yes. I mean, as I look at at least the argument section of the brief, I don't see that argument in there. Can you point me in the brief where you actually argue that the stipulation was not to trial court making a finding of need, or that the parties stipulated the need, or the parties were stipulating the financial affidavit be considered? Did you actually argue that?
Well, in my summary of the facts, let's see.
Anyway, in the interest of time,
Yes.
if you want, while you're, when we go on to the rebuttal argument, you can look it up.
Okay.
At the end, I'll give you a chance to answer Judge Smith's question with page number and reference where.
Excellent, thank you.
That'll work. All right. Well, thank you, Counselor. And Al has
Thank you.
5 minutes, but you have 8, but you already asked for 5, but hopefully you do that.
Okay, first, the stipulation was not as to, we get to look at the financial affidavit, the stipulation was as to the former wife's present income. And that's on page 1118 of the record on appeal. And it just says year to date, she's currently making $13,305 per month gross.
What do you say as to the argument that you used the affidavit and reference it in the argument for support?
Didn't use an affidavit, used this, used exactly what they testified to. And also, you actually read the passage from Worthrum that I was gonna read about the burden. The burden was on her to prove her need. They said, you know, how are these fees paid? We don't know if she had a beneficiary, like someone that just paid the fees and wasn't expected to be paid back. She may not have a need. We don't know because she never testified that she had a need for her fees to be paid.
Counsel, what's your response to Mr. Luther's assertion that we should remand with an opportunity for additional hearing because former wife was cut off, I guess, mid-hearing based on this whole direct verdict?
Well, he did not ask for a continuance. He did not ask to be allowed to present more evidence. He just said, I have some evidence. The wife has had her day in court. The judge reminded them, hey, I haven't heard anything about attorney's fees. So it was their burden to show that there was a need through testimony and through evidence, and they failed and did not prove the need. And I just ask that this court reverse and strike the order.
Okay.
Thank you, Your Honor.
Do you have a reference that you want to?
Yes, for Judge Smith, perhaps I wasn't crystal clear in citing the financial affidavit, but on page 10 of my brief, I said the former husband consistently acknowledged that the parties stipulated the former wife's financial circumstances at the initial trial. And the way they did that was by citing the financial affidavit and the judge saying, I've looked at the financial affidavit and nobody raising anything to that. So in my brief, when I say that he stipulated to her financial circumstances, it's akin to he stipulated to the judge considering the financial affidavit. But I agree that at no time did the former husband say, yes, I agree that she's proven her need. I understand that. But that's where it is in my brief.
Mr. Harris, did you have a question, follow-up?
Thank you.
Out of fairness, since it was more than just a page number or a reference, do you have anything that you want to say?
No, Your Honor, I just say it wasn't a stipulation as to the financial affidavit, just to what she was earning that year. Thank you, Your Honor.
Thank you.
We'll be in recess until 11.